How's everybody doing? Great to be learning with you on a Tuesday, Yom Shlishi. Let's light up the darkness. Oh, it's good to be back. Missed you guys. Sorry we took those extra 2 days, but wow, was it worth it from our point of view. We had a relatively last minute, we announced it before, but relatively last minute trip to the Grand Canyon. It's something that I've been meaning to do for 30 years. Nina basically the same, and we finally did it. And I got to tell you, the Grand Canyon lives up to the hype. Amazing. The canyon itself, the national park that surrounds it, there's cute towns in the area, but the canyon, it's like, wow. I'll be sharing some pictures of that on our Facebook page. I already put one video blowing shofar at the Grand Canyon on our Instagram. And also the blessing. So there's a blessing that you say when you encounter not just an ordinary mountain or an ordinary canyon, but a mountain. You see Mount Everest, perhaps Mount Rainier, Mount Kilimanjaro, a grand mountain or a grand canyon. So you say, blessed are you, Lord our God, ruler of the universe, who makes the work of creation. And there it is. And it was just, I wanted to say that blessing. It wasn't just like fulfilling an obligation. It's like, wow, you don't often get to see so much all at once. So if you haven't been to the Grand Canyon, highly recommend. Who's in the house? Shandora in the Bronx, Bella in Florida, Yehuda in South Carolina, Guy in Ohio, Karen in Northern California, Melissa in Great Neck, Joe in Boston, Bill in mid-Missouri, who says he might be a bit distracted for the first bit of class. Something that I think you'll appreciate relatively early in the class, Bill. Sharon in New Jersey. Says Bill, what was that line from The West Wing? The Grand Canyon is one of those things you should always take a chance to see because it's one of the few things that live up to the hype. I wasn't even referring to that, but there you go. Exactly. And it was Yael in Washington, Marjorie in Georgia, Aoife in Florida, Eleni in Silver Spring, Marie in Freeport. Welcome, everybody. Okay, another double. This... wonderful, right? These pages in Tractate Bava Basra, 23rd volume of the Talmud, so many of them are short, and it's so nice around holiday time when we have to miss days. I'm not even sure if we are behind, right? So today we're doing pages 114 and 115, and per the schedule, today's October 15th, the Daf Yomi schedule is on page 112. So we're still ahead, but we'll have a class tomorrow, Wednesday at noon. Then Sukkot starts tomorrow night. So we won't have class Thursday and Friday. And I think we're on. Nina posted the schedule, but I think we are Motzi Shabbos, right? I'm not sure. But the schedule's posted on the Facebook page. But at any rate, we have to miss at least Wednesday and Thursday and Friday this week, Thursday and Friday next week. I think Wednesday, Thursday, Friday next week because of Hoshana Rabbah. I'm always busy all day on that day. Okay. At any rate, right now we're ahead of schedule, but we're getting another double daf. So pages 114 and 115, continuing our discussion of Mishna number 1. Here in chapter 8 of Tractate Bava Basra. And we've been talking about, in the absence of a last will and testament, how property is distributed to the heirs, who inherits from who. It's obvious, right, that if a father, God forbid, passes away, his son is going to inherit from him. And as is said explicitly in the Torah, If there is no son, his daughter inherits from him. The father inherits from the son in case, God forbid, a son predeceases a father. But does a mother inherit from her son if, God forbid, a son dies before the mother? No, unless certain conditions are met. But generally, a mother doesn't inherit from her son. A son does inherit from his mother. These are the kinds of rules that we're looking at. And again, these are in the absence of a last will and testament. And today we're actually going to talk a little bit about, it's not just a modern phenomena to have a will. That's quite an ancient idea. And we're detailing it even here. If somebody is, for example, ill, and he hasn't made his will known or hasn't made a last will and testament before, what does he have to do in order to do that, even as he's lying, very ill on his bed, and this might be his last chance to do that? Now, preparing for the class today, it dawned on me, I've heard this phrase a million times, I'm sure you have too, last will and testament. What's the difference between a will, and let's say a last will, okay. If you have a will and then later you change your mind and you write another will, so I understand the difference between a will and a last will. Got it. What's testament? Why is testament part of this phrase? What does it come to add? And, I went to law school. I was a lawyer briefly. I feel like what I learned about last will and testament is something that I should have known already, but I didn't know it until I looked it up today. So this phrase, last will and testament, is similar to aid and abet, break and enter, terms and conditions, free and clear. Right? And we hear those phrases all the time, and we feel like, well, it must be that the second word, adds a little bit of information to the first word. Yeah, no, it doesn't. It's a different language. That's what's going on here. So there used to be in the English court system, right, and the American judicial system is based on the British, right, common law system, judicial system. But in that British system, there was a period, pretty long period, hundreds of years, where there was a combination of Old English and Law French. I just know Bill already knows this, right? Bill, you already knew this. But this Law French, which is a kind of pidgin language, based on French, of course, but not the same as common spoken French, even of that period, mixed with Englishisms, Latin, etc. I remember in law school, the first case that we had in torts class was called I de S. And it was about assault, right? Which is not the same. Assault and battery is different. Assault means you frighten somebody. Battery means you strike them. So assault and battery is not one of these things. But I de S, I guess I always assumed it was Latin, but there was probably that French was coming to have an influence there. So what you have is that for a time, for the sake of clarity, because two languages were being used in the British judicial system, they had two terms so that everyone would understand whichever language they were more familiar with. Now we just think of a lot of these words as, well, it's just English, but it wasn't English originally. It came from French, and specifically this law French. So the two words mean the same thing, they just have a different origin, and keeping them together is something that we have preserved until today. You've heard hear ye, hear ye, hear ye, right? You may have also heard oye, oye. That's the French, right? The O-Y-E-Z. But isn't that interesting? Last will is English. Testament, in this sense, is from Law French. Aid and abet, Old English and Law French. Break and enter, who would have known? But yeah, terms and conditions. Terms and conditions should have been a clue to all of us, right? Like, what's the difference between terms and conditions? Now, there is something that is a condition for something else, Yeah, maybe in contractual parlance. But here, that's not what it means. Terms and conditions, they mean the same thing, but the phrase runs together. I thought that was fascinating. So if you knew it already, pardon me for the digression. If you didn't know it, hopefully you found that as interesting as I did. And there's lots more phrases in that bailiwick. Okay, we pick this up on page 113b near the top. Rabba Bar Chanina taught a baraisa before Rab Nachman, a verse in the passage concerning the double portion inherited by a firstborn states, "Then it shall be on the day that he causes his sons to inherit that which he has." That's Deuteronomy 21:16. And the addition of the phrase "on the day" teaches that it is specifically during the day that you may distribute inheritances, but you may not distribute inheritances at night. And Abaye said to him, "That cannot be the law. As if that is so, it ought to be that only one who dies during the day is the one from whom his children inherit, but with regard to somebody who dies at night, his children do not inherit from him." And this is not the case, because obviously the inheritance happens the moment that that person dies. So are you saying that if people only inherit during the day, that if only the inheritance only works if the deceased left this world during the day? Can't be. Obviously, that violates common sense. So Abaye suggests a different interpretation of Rabba Bar Chanina's statement. Perhaps you set a distinction between day and night, not with regard to whether an inheritance happens, but rather the adjudication of inheritances. As judges are permitted to sit only during the day. That's interesting because that is an existing halacha. We haven't talked about it before, I don't think, but I facetiously titled today's show Aid and Abet. I already explained why, and Night Court, which there was a comedy called Night Court, and there is Night Court, right, like traffic court. It often meets at night, but a rabbinic court, a beis din, does not meet at night. Right? So it's part of the halacha that when judges sit to deliberate, they do that and hear, witness testimony, etc. They do that during the day. And so what they're saying is here, well, just like the rest of judicial matters in a rabbinic court, if there's going to be an adjudication, that has to be done during the day. And a proof for this distinction is, as it is taught in a baraisa, a verse in the passage concerning inheritance states, Numbers 27:11, "And it shall be for the children of Israel a statute of judgment, teaching that the entire portion was placed together to be considered a matter of judgment, and therefore it is subject to the procedural rules of matters that are decided by rabbinic courts." So says Abaye, and this is in accordance with the statement of Rav Yehuda. As Rav Yehuda says, in a case where there were 3 men who entered a room to visit a sick person, and the sick person desired to write a will, right, his last will and testament, in order to distribute his property following his death. So if the visitors wish to do so, they may write his will and sign it as witnesses. And if they wish, because there's 3 guys, so they can do the simple thing of, write down what he's dictating to them as his last will, and then one of them writes it down, let's say, and the other 2 can be witnesses. That's why there's 3 there. But because there's 3 of them, they have an additional option that they may act in judgment, i.e., they may act as a court in the matter, since there are 3 of them. Therefore, they can determine that the will has the validity of an act of court. And acting as judges sitting in a rabbinic court, they then formally transfer the property to the heirs in their capacity, not just of a scribe and witnesses, but as judges sitting in a court. And so they will transfer the property to the heirs in their capacity as a court. But if only 2 come to visit the sick person, They may write the will and act as witnesses, but they may not act in judgment, since 3 are required to form a court. And Rav Chisda says this law was taught only in a case where the 3 came to visit during the day. Now we're on 114a. But if they came at night, even if 3 of them came to visit the sick person, they may write the will and sign it as witnesses, but they may not act in judgment as a court. And what is the reason that they may not act in judgment the next day? It is because they are already witnesses to the will of the deceased, and there is a principle that witnesses cannot become a judge, i.e., one who acts as a witness in a particular matter cannot become a judge with regard to the same matter. And Rabbi Bar Chanina said to Abaye, yes, it is indeed so. This is what I was saying. Because the procedural rules of a rabbinic court require that it meet during the day, that same applies if a court is going to convene to dispose of the assets of an inheritance in a case of inheritance. So 3 go to visit a sick person. He wants to tell them what his last will is. They can either just write it down and act as witnesses to it, and then later, if that's going to be challenged, it'll be in some other rabbinic court, or they could just convene a court at that moment and hear the testimony of the person who's lying on his deathbed, and they can adjudicate the matter and pass judgment right then and there. But it has to be done during the daytime for the reason that we just mentioned. Now, after mentioning Rav Yehuda's ruling, the Gemara cites a related dispute. It was stated, with regard to a transaction, until when may one of the parties renege on the transaction? Now, what does that have to do with inheritance and the law of heirs? We're going to get to that in 1 second, but we were talking about this pretty recently, just a few weeks ago, about people who are doing business together, and until when can they renege on the deal? In other words, when have they finalized the deal, and when is the deal not finalized? So now we'll see how this is relevant to inheritance. With regard to a transaction, until when may one of the parties renege on the transaction? Rabbah says, as long as they are seated in the same location, they may renege on the transaction. In other words, they come to an agreement, but they didn't get up from there and go their separate ways. So even though they came to an agreement, one of them can still change his mind, because it's like, okay, well, we agreed to do it, but then, I realized I didn't really want to do this. We're still sitting here. We're still talking about it. Yeah, I said I want to do it, but it's in the same conversation that I said I don't want to do it. It's more like he's hemming and hawing. They haven't finalized the deal. So as long as they are dealing with the matter, meaning they are still sitting and discussing, they may not renege on it. Now, Rav Yosef said, it stands to reason in accordance with my opinion. I'm sorry, so there's 2 opinions. Rabbah says, as long as they are seated in the same location, they may renege. Rav Yosef says, as long as they are dealing with the matter, i.e. they are still discussing, they may renege. Right? So one says, as long as they're having the same conversation, the other one says they still have to be sitting. Right? Once they get up, that's like it's done. The negotiation's done. We agreed on it. Now there's no more reneging on the deal. Now, Rav Yosef, the one who says as long as they're still having a conversation, but it doesn't tie it to sitting, he says it stands to reason in accordance with my opinion. As Rav Yehuda says, in a case where there were 3 men who entered a room to visit a sick person, and the sick person desires to write a will in order to distribute his property following his death, if the visitors wish to do so, they may write his will and sign it as witnesses. And if they wish, they may act as a court in judgment. And if it enters your mind that one may renege on a deal as long as they are seated in the same location, then let us be concerned that perhaps he will renege on his decision. How can the visitors act in judgment in a case where the matter has not been resolved, as the sick person may still change his mind? Right? If you're saying it's only over when we get up, well, the guy on his deathbed isn't getting up. So as long as he hasn't gotten up, there's no ending the discussion per the opinion of Rabbah. Rav Yosef says Now, when you reach an end of that discussion, okay, we made a deal. Now we can't back out of it. And as evidence, he brings this idea that the three people who come to visit a sick person can take his last will and testament and then witness it. So once it's witnessed and done, it's done, and he can't change it after that. But if, according to the opinion of Rabbah, as long as they're still seated there, he could change it. He could renege on it. So you can't say it's ever been finalized, I guess, until he dies. Now, Rav Ashi said, I stated this law before Rav Kahana, and I asked him. And according to the opinion of Rav Yosef, does it work out well? But even according to his opinion, there should be a concern that perhaps he will renege on his decision. As Rav Yosef holds that one may renege on a transaction as long as the two parties are still dealing with that matter. So rather, what have you to say? That according to Rav Yosef, Rav Yehuda's ruling applies where they withdrew from discussing that matter to a different matter, so he can no longer renege on his decision? Well, so too, according to Rabbah, one can explain that Rav Yehuda was referring to a case where they arose and then sat down again. They made a formal act of getting up, then they sat down again, but it was done. So although no support for Rav Yosef's opinion was adduced from Rav Yehuda's ruling, the Gemara nevertheless states, and the law is, the halacha is, in accordance with the opinion of Rav Yosef. In the disputes concerning the division of a field, which was discussed above at page 12b, reneging while they are discussing the same matter, discussed here, and a half of one's property, which will be discussed below on page 143 when we reach it. Now, the Mishna teaches that a woman, how do we get to this, right? Why we were talking about inheritances, and then we were talking about, that the law of inheritance said on the day, right? And then does that mean that he has to die on the day? No, it just means that if there's going to be an adjudication in the matter, that has to be done during the day, and that's relevant when three people come to visit a person, who's lying sick in bed. If they come during the day, they could act as a court. If they come during the night, they can only act as a scribe and witnesses to the will. Okay, we're on page 114b, and let's just get back properly to the law of inheritance. So the Mishnah teaches that a woman bequeaths to her son, right? So if she dies and she has property, it goes to her son, and to her husband, and to her maternal uncles, right? Her father's brothers. But she does not inherit from them. It's not reciprocal the way it is with a father and son when we're talking about a mother and son. So the Gemara asks, why do I need to say this? But it is already taught in the former clause that a man inherits from his mother and a man inherits from his wife. So we already know, sort of looking at it from the other side, that a man inherits from his wife, but a wife doesn't inherit from her husband, right? If he has children, the children inherit before the wife does. Again, remember, this is all in the absence of a last will and testament. You can have anybody inherit your property that you want. But in the absence of a last will and testament, these are the laws that are applied, both by Torah law and rabbinically, as the ones that are by Torah law are expressly stated, or close enough, and by rabbinic is what the chachamim, what the sages have derived from what's expressly stated in the Torah. So, why do I need to state that a woman bequeaths to her son when we already know that his son inherits from a mother and that a man inherits from a wife? And the Gemara answers, this teaches us that the law of a woman who bequeaths to her son is similar to that of a woman who bequeaths to her husband. Meaning, just as with regard to a woman who bequeaths to her husband, the husband does not inherit property through his wife while he is in the grave, i.e., if a husband predeceases his wife, then his relatives, such as children from another marriage, do not inherit the wife's property through him, but rather the wife's own relatives inherit her property. And so too the same law applies with regard to a woman who bequeaths to her son, that the son does not inherit property through his mother while he is in the grave. Meaning if he predeceased her and he left, let's say, paternal brothers, right? He had brothers from his father. In other words, his father had another wife besides his mom, and he has brothers, right, from his father and his father's other wife. Now he predeceases his mother. So do his paternal half brothers inherit what his mother leaves, through this boy who's unfortunately predeceased his mother, so he's in the grave? No. So even though she had a son, and that son had other relatives, now that she outlived her son, when she dies, right, and she didn't leave a will, where does her property go? It goes back to her father's house, right, and her relatives from her father's house. So in both cases, the woman's own relatives inherit her property. It doesn't go to people who are not really related to her, though they are related to her husband or her son that predeceased her. Now, with regard to the law that a mother inherits from her son, which we just said she doesn't, unless very special conditions, right? So with regard to the law that a mother inherits from her son, the Gemara notes that Rabbi Yochanan says, in the name of Rabbi Yehuda ben Rabbi Shimon, by Torah law, a father inherits from his son, right? If God forbid a son predeceases his father, so a father inherits from the son, and a woman inherits from her son if the father is no longer alive. As it is stated with regard to a woman receiving an inheritance, and every daughter who possesses an inheritance from the tribes, plural, tribes of the children of Israel. Since the plural term tribes includes both her father's tribe and her mother's tribe, the verse juxtaposes the tribe of the mother to the tribe of the father. In that, just as with regard to the father's tribe, a father inherits from his son, so too with regard to the mother's tribe, a woman inherits from her son if the father is deceased. This is Rabbi Yochanan stating in the name of Rabbi Yehuda ben Rabbi Shimon. So it seems to be at least the opinion of Rabbi Yehuda ben Rabbi Shimon. But Rabbi Yochanan himself is going to object to this. Now we're on page 115a. Rabbi Yochanan raises an objection to this opinion of Rabbi Yehuda ben Shimon from our Mishna, which teaches a woman with regard to her son, a woman with regard to her husband, and maternal uncles all bequeath to their respective relatives. A mother bequeaths to her son, can leave property to her son, but she doesn't inherit from her son. They do not inherit from them, said our Mishnah. So our Mishnah states explicitly that a mother does not inherit her son's property. Rabbi Yehuda ben Shimon said to Rabbi Yochanan, with regard to our Mishnah, I do not know who taught it, i.e., I am not aware of any Tana who concurs with its ruling, and it is not the accepted law. I guess our Mishnah is not the accepted law. So the Gemara asks, but let Rabbi Yochanan say to Rabbi Yehuda ben Shimon that the Mishnah is written in accordance with the opinion of Rabbi Zechariah ben Hakatzav, who we saw last week, who, as noted on page 111a, does not derive the law that sons precede daughters with regard to the inheritance of their mother from the word tribes. Recall that Rabbi Zechariah ben Hakatzav said that if a father has already died and a mother has property and she has a son and a daughter, that in that case the son and the daughter inherit equally from the mother. That ended up being a minority opinion. We don't follow that. Just like a brother precedes a sister when inheriting from a father, a brother precedes a sister when inheriting from their mother. But at least according to Rabbi Zechariah, it seems that brothers and sisters inherit equally from their mother, even if they don't inherit equally from their father. And how does he know that? He derives it from this plural word tribes, as we saw last week. Now the Gemara answers, the Mishnah cannot be interpreted. Our Mishnah cannot be interpreted in accordance with the opinion of Rabbi Zechariah ben Hakatzav, as it teaches, and the sons of a sister inherit, but do not bequeath. And a sage taught that the Mishnah is referring only to sons of a sister and not to daughters of a sister. And we say, with regard to what law Is there a distinction between the sons and daughters of a sister? And Rav Sheshes said the distinction is meant to teach that where there are sons as well, they precede the daughters in inheriting from their maternal uncle. And if it enters your mind that the Mishnah is written in accordance with the opinion of Rabbi Zechariah ben Hakatzav, doesn't he say that both the son and the daughter are equal with regard to the mother's property, as they inherit equally? And the Mishnah stands in contraposition to Rabbi Zechariah's ruling, and therefore cannot be written in accordance with his opinion, since it reflects that brothers inherit ahead of sisters, for fathers as well as mothers. And the Gemara asks, and the Tana of our Mishnah, whichever way you look at it, is inconsistent. If he interprets the word tribes, then a woman would also inherit from her son, as noted above. And if he does not interpret the word tribes, then from where is it clear to him that a son precedes a daughter with regard to the property of the mother? Both laws are derived from the same source, so how can the Tana accept one and reject the other? And the Gemara explains, actually, the Tana of the Mishnah interprets the word tribes, but it is different here with regard to a woman inheriting from her son. As the verse states, Numbers 36:8, and every daughter who possesses yoreshet, an inheritance, from the tribes, which teaches us that a daughter inherits yoreshet from two tribes, but she does not bequeath to two tribes. She bequeaths only to her father's tribe. And that concludes our discussion of Mishnah number 1 here in chapter 8. Now, Mishnah number 2. The order of precedence, right, who precedes who, with regard to inheritances is this. The verse states, if a man dies and he has no son, then you shall pass his inheritance to his daughter. That's Numbers 27:8. And this teaches that a son precedes a daughter. Additionally, all descendants of a son precede a daughter. A daughter precedes the brothers of the deceased. And additionally, the descendants of a daughter precede the brothers of the deceased. So if a man dies, right, and he has a son, his son inherits. If he has no son but he has a daughter, the daughter inherits. If he has no son and he has no daughter, let's say he never had a son, he had a daughter, the daughter died, but she had children. So this man, when he dies, he has grandchildren, right? And he also has brothers. So you might think that, well, if he has no daughter, then his brothers inherit, but his daughter did leave him grandchildren. So his grandchildren, who are the children of his daughter, will inherit ahead of his brothers. Even though he has no child living when he dies, he has descendants through his children, those grandchildren, and they will inherit ahead of his brothers. And then let me just sort of a summary of where we're headed with all of this. I'll come back actually. Just let me finish the Mishnah. And so says the Mishnah, this is the principle concerning anyone who precedes another with regard to inheritance. His descendants precede the other as well. And a father who inherits precedes all of his descendants, right? So if, this guy dies and he leaves grandchildren and he leaves brothers, but let's say he also left his father, right? So his father has great-grandchildren. Well, the father will inherit ahead of his great-grandchildren. So as long as, if somebody doesn't have children, but he has a father, when he dies, and the father inherits. And the reason it always goes first to the father is because then when the father dies, it's going to come back down anyway to his descendants. So it's interesting, though, that it seems that a father would inherit ahead of the deceased's own grandchildren. Why? Because a father who inherits precedes all of his descendants. Now, just a kind of where the law ends up. This is the halakha from Shulchan Aruch. A son and his descendants precede all others with regard to the inheritance of the deceased, right? So if a guy dies and he left a son, his son gets the inheritance. And if he left his own son died, but he left grandchildren, but he has grandchildren through that son, then the grandchildren inherit ahead of anyone else. If the son died with no offspring, then the daughter of the deceased and her descendants inherit. If she died with no offspring, then the father of the deceased inherits, right? So his own children come first and his grandchildren come first, and they come ahead of the father, right? God forbid someone dies and his father's still alive, but he left descendants, either children or grandchildren. The children and grandchildren do inherit ahead of the father of the deceased. If he leaves no children and no grandchildren and no father, then the brothers of the deceased and their descendants inherit. If there are no brothers or descendants of brothers, then the sister of the deceased and her descendants inherit. If the deceased had no sister, or if the sister died without descendants, then the paternal grandfather of the deceased and his descendants, i.e. the deceased's uncles and aunts, inherit. If all of these people are no longer alive, then the paternal great-grandfather and his descendants inherit. And this process may continue from generation to generation as far back as Jacob, our patriarch. In other words, cousins, right? If you have no living children or grandchildren, nor siblings, nor parents, right, then you would go back to, okay, your grandfather and then his descendants. So now you're talking about your cousins. And if you have no first cousins, so then you go back up further and then you come back down again, and you're talking about, cousins once removed, twice removed, 3 times removed, etc., until you find the closest relative. Okay, that's Mishnah number 2 here in chapter 8. Now the Gemara. And I'm almost done. So questions or comments, please get them in now. The sages taught. The verse states, if a man dies and has no son, then you shall pass his inheritance to his daughter. Numbers 27:8. I have derived only that a son precedes others with regard to the inheritance of the deceased. From where do I derive that a son of a son, or a daughter of a son, grandchildren, or a son of a daughter, or a son of a son, or the daughter of a son also precede the other relatives of the deceased? How do we know that grandchildren come ahead of siblings, for example, or even ahead of their great-grandfather? The verse states, if a man dies and he has no son, ein lo. So the word ein is written with an aleph, yud, nun. Therefore, the sages read it as if it states, investigate with regard to him. Ayin alav. Put eyes on it. To search for the descendants of his son and give the inheritance to them if they are found. The next verse states, and if he has no daughter, then you shall give his inheritance to his brothers. I've derived only that a daughter precedes others except the son and his descendants with regard to the inheritance of the deceased. From where do I derive that a daughter's daughter, or a son of a daughter, or a daughter of a son of a daughter also precede the other relatives of the deceased? And the verse states, and if he has no daughter, ein lo. And the word ein is written aleph, yud, nun. Therefore, the sages read it as investigate with regard to him, ayin alav, to search for descendants of his daughter and give the inheritance to them if they are found. Now on page 115b, and the Gemara asks, how so? I.e., how is the investigation performed when he has no offspring at all? And the Gemara answers, the family lineage that determines the inheritance is successively examined up to Reuben, the son of Jacob. I.e., the heirs are determined by investigating the family genealogy, and that investigation can extend all the way to Reuben, the son of our forefather Jacob. And the Gemara asks, let us say until Jacob himself. Why only up until Reuben? Since if none of Reuben's descendants survive, one would have to examine Jacob's descendants. And Abaye said in reply, it is learned as a tradition that a tribe will not be eliminated entirely, and some descendants will always remain. So if no matter how far back you have to go, you're going to identify, some kind of the closest living cousins. And this really kind of brings home that the point that the Jewish people are a tribe, right? We're often called a tribe, but really what we are is members of one of the tribes, right? So what were the 12 tribes? The sons of Jacob. And really we're a tribe because we're a family. The family has adopted other members, right? So when somebody converts to Judaism, they're not just joining a religion, they're being adopted into a family, right? So all Jews are related in that way, and you're always going to be able to find some relative, even if seemingly somebody's entire family has perished. You just have to go back far enough if you can find it, and then come back down again. Having found the ancestor, then you can come look at the living descendants of that ancestor, and the inheritance would go there. But as always, this is all good reminder that every person should write a will, especially if you have children. And of course, there are many matters, besides where your property goes, health and medical directives, care of children, ethical will. I mean, there's a lot of things that should get addressed in a last will and testament. That's where we're going to knock off, and we'll pick it up tomorrow, Wednesday special time, noon Pacific, because Sukkot begins tomorrow night. Okay, let's take some questions and comments as my Google Docs reloads. Come on. Taking questions and comments on our double daf today, pages 114 and 115 here in Tractate Bava Basra. Fred, is not testament an oral will rather than a written one? I might have thought that with you, because like the word testimony seems to imply, what somebody is testifying. But you can testify in writing. And what I learned today is no. Last will and testament is the same as last will. And it's called last will and testament because of that English tradition, British tradition of having Old English and Law French. Not Old French, not French, but Law French, right? So Old English and Law French is how you have phrases like last will and testament, aid and abet, and some of those other examples, break and enter, terms and conditions, free and clear. Bill, I did already know. I knew you knew, Bill. I knew it. I did already know. And we can blame William the Conqueror for it. Fun fact, the Eldridges are listed in William's census, the Doomsday Book, which tells you how the common folks saw the tax man. And even though Eldridge is a Saxon name, we're listed as Norman, which means French. Norman nobles, which means we switch sides fast. What movie was it? That switching sides. Once you see which way the war is heading, somebody switches sides. I'll do what I've always done, switch sides. Was it in Braveheart? Was there something like that? I can't remember. But thank you for sharing that, Bill. Jonathan, if there were 3, but not all educated, could they sit as judges? Wouldn't they have to be scholars? Excellent question, Jonathan. I had the same question. I was like, what do you mean? Just because 3 people enter the bedroom of a sick person as he lays there dying, and they're going to say, yeah, we're going to convene as a court and accept, instead of just witnessing what your last will is, writing it down and then being witnesses to it, we're going to act as judges? How can they do that? And the note that I read about is apparently they shouldn't, but if they do, we follow their ruling. I saw that, right? Let me just make sure that I saw that. I'm not making it up. 3 who entered. Wait a minute. Right. So if 2 men visited a sick person, and he declared before them how he wished to bequeath his property, they may write his will, but they cannot adjudicate the matter. If there were 3 visitors and the sick person stated an irrevocable declaration of his will, then they may either write his will as witnesses or adjudicate the matter, meaning that they have the authority to distribute the property to each heir according to his portion and rule concerning any uncertainties that arise with regard to the conditions of the will. None of the heirs can contest their authority and insist on transferring the case to the jurisdiction of another court. And this law applies when the sick person stated his will during the day, but if he did it at night, the visitors are authorized only to write the will, but not to act as judges, as judicial deliberations cannot take place at night. And the Rima writes that if they did adjudicate at night, their judgment stands, but the Shach disagrees. Now, but with regard to do they have to be qualified as judges? Did I see this, or is my memory playing tricks on me? I'm not seeing. Now I'm not sure. What is for sure is that witnesses to a document cannot later become judges. But as for how qualified do they have to be? Do they have to be people who could have been dayanim, judges, right? Competent judges? Now I'm not sure. I would hope, right, that it's not just like Tom, Dick, and Harry can just say that, well, yeah, we are not just going to be a scribe and witnesses. We're the judges. And do you know the law, Tom? Yeah, I know the law. Yeah, we're going to give it all to the kid who's nice to us. So, and have a self-interest. So I don't think so. I think that they need to be qualified as, people who can sit in judgment. But I'm not sure. I mean, there are times when a beis din can be comprised of non-rabbis. I mean, just like, people who are somewhat learned. It's not that anybody. They need to have some understanding of Torah law, even if they wouldn't otherwise be qualified to sit on a rabbinic court, and their judgment will stand. And I don't know. I'm not sure if this is one of those situations. I think I was wrong when I said it seems like it would stand. The answer is I don't know. I need to look that up. Okay. Sharon. But ayin, I is written with the letter ayin, but ain is spelled with an aleph. How are they connected to one another? I'm not sure. I'm not sure why they said that they can make that distinction. That says ain lo, there is none. That's with an aleph, and then they're saying that investigate is what they're reading out of that word, right? Ain is written aleph yud nun. So investigate ayin alav. You know what? Maybe it's not the same word as ayin, like an eye, but ayin is investigate, and I was making a mistake and tying that to, an eye. Sharon says the requirement for 3 is also the reason we say a zimun before Birkat Hamazon. It is connected to convening for bearing witness, much like a court. Exactly. So Sharon is alluding to the fact that when after we eat a meal being, we had bread with it, we washed and ate bread, so we made a blessing on the bread. Now this is considered a meal rather than a snack. Okay, so then afterwards we have to say the full blessing, the grace after the meal. If 3 men or more ate together, then when they say the blessing after the meal, they first have a formal convocation. Gentlemen, let us bless. And so they just add like 3 short before the benching, before the grace after the meal. And what Sharon is saying is that because formally what they're doing is convening a court to hear and bear this testimony and utter the blessing together. And that's the difference between when 3 have dined together versus 2 or just 1. That's what I've got for us today. And God willing, we'll be learning together again tomorrow, Wednesday at noon. Have a good night.